Hello everyone, welcome back to the video updates. It's Sade. Today's video is going to discuss the options that somebody might have if an ex was supposed to sign over the deed to property to that person per their divorce decree and has refused to do so. So most of the times when we get this question, there would be a situation where it's been maybe 6 months to 2 years and the exes are not really talking to each other. You know, people don't feel good about a divorce typically, so it's not unusual that the other party doesn't want anything to do with the ex and so does not want to read the emails, does not want to sign anything at that point, even though they might have agreed to at the time of the divorce. Now, what are the options that this person would have if they are in this kind of situation where there are two names on the title and the ex has disappeared or refused completely to sign over the deed as they thought they had agreed? The options that you have would depend on how well written your divorce decree is. And when I'm talking about divorce decree, I'm talking about the final orders, the final court judgment or documents regarding the divorce itself, because that is the document that will contain the terms of how the real estate is supposed to be handled as well. Now, if you had a lawyer helping you, most times it will be well written. If you did it on your own, you know, DIY, sometimes you just don't have any, you don't have enough information to be able to write it properly. If the decree is written very well and very clearly as to the rights and obligations of the parties, and it specifically says that your ex was supposed to sign over the deed once a particular condition was met, and that condition has been met, then that is a very well written divorce decree or very well written divorce order. And what this means is that a lawyer's approach is going to be completely different when you have a very well written divorce decree that's enforceable. So when it's well written, it's just more enforceable. It's more enforceable in terms of the legal enforceability of it. So you could go to court and try to enforce that particular divorce decree because the language inside is very clear and concise as to what was supposed to happen. And so that ex is going to be notified that you are trying to enforce, and then there will be different types of things that a court could do to try to coerce compliance. Now, most people are not still going to show up because they don't want to deal with you. They don't care. They're just really maybe depressed about the whole thing, or they're just doing it out of spite. Now, the court isn't going to get any like constables or sheriff to go arrest somebody to force them to sign a deed. But what they can do is hold that person in contempt. And ultimately, when you're held in contempt over and over again, there could be an imposition of jail time for disobeying the court. That's just because the contempt laws are slightly different, but the initial steps would be to fine that person. So you can ask the court for a fine, and you can definitely ask for your attorney's fees back if you're having an attorney to do this for you. And I would suggest that you do have an attorney do this for you, because it's very difficult to kind of navigate on your own if you've never done it before. The second scenario is a scenario where the divorce decree was not very well written or was silent, even though you had a side agreement with your ex saying that the ex was going to sign over the deed once you paid the ex a certain amount of money or once you refinanced to remove the ex's name. So once you're at the point of trying to refinance, you'll find out that the ex is no longer responding to you, doesn't want to deal with you, says that that was not the agreement. So in that case, the divorce decree is not helping us to really pinpoint what was the agreement, to nail it down. And so you will not be able to enforce that kind of a decree because the enforceability is always confined to the four corners of the document. So it has to be in writing. It has to be signed by all the parties involved, which would be both of you really. Your attorneys might have signed it if you had attorneys. Now, if the decree is not clear, as I said, and it's either, kind of vague, or it's ambiguous, or it's silent completely, you will end up in a different kind of approach or a different kind of option that you have. You will not be able to enforce it successfully, I don't think. What you will have to do is start a totally different lawsuit that would relate to the real estate, and it's going to be a lawsuit to quiet title in yourself. You'll have to prove up why the court should make the ex sign over the deed to you, or why you believe that there was an agreement where you were supposed to get 100% title to that property. And you might be able to prove that in equity, even though there was no written agreement. You can show your history of making all the payments by yourself, and upkeep of the property, paying for everything and paying for all the maintenance and repairs. And maybe the judge will be able to find that there was an implied agreement somewhere. But typically with real estate deals, you want it to be in writing. That's why it doesn't hurt. It's actually really, really a smart move to get a lawyer involved in your divorce if you have real estate involved. And you want to make sure everything is done correctly from the get-go, because the cost of redoing things, reworking things, and correcting things is usually much more than the original cost of hiring a lawyer. So between those two approaches that I mentioned, remember, the enforcement is available if the decree is well written, and then the quiet title action most likely if the decree is vague, ambiguous, or silent as to the rights of both parties. And the enforcement lawsuits are going to be done in the original divorce case. So you don't have to reopen anything. So it tends to be cheaper overall. It's cheaper overall for you for that reason. And it's cheaper as far as court costs and as far as legal fees. The brand new case is going to be more expensive in general, and also because the legal fees are going to be more, because if your decree had been well written in the first place, then you would have never needed to go and open a brand new case entirely. So the burden of proof is going to be a little bit higher. In that case, it's harder to meet as well, most likely. And then the last thing I wanted to say is that whether you go through the enforcement or you go through the brand new lawsuit, the end result is that you will end up either with the ex showing up and being made to sign over the deed just by the pressure from the court and from you, or the ex might completely blow everything off. And if the court finds that you've been able to prove that you are entitled to 100% ownership of the property, then you'll be able to get a court order that would show that you are 100% owner, and your lawyer or you will then file that into the county's property records. That document alone, the order that's signed by the judge and filed into the county's records, it's sufficient to prove to anybody out there that you are 100% owner of the property now. So even without the ex signing over a deed to you, that order is going to work in your favor. It's going to be good enough for title companies, for buyers and their agents and their lawyers as well. So that's what I wanted to cover today really quickly. That question comes up quite often. So I wanted to say the only way you can prevent this from happening, by the way, is to make sure that the ex signs the deed at the same time that the divorce decree is being signed. But it's very difficult to get that in some situations because the condition that was supposed to occur has not occurred yet, which is usually for you to pay the ex some amount of money to be able to get 100% ownership of that property, or for you to pay off the mortgage. So you really don't have a lot of choice there. But the lawyers, if you have a lawyer helping you, they can make sure your divorce decree has such clear and concise language that is going to be so easy to enforce if this ever happens. So my suggestion is to always consult with a lawyer while you're doing the divorce if there's real property involved. If you feel like you don't have the funds at the beginning, but towards the end you're at the point where you and your ex have reached an agreement, you can get a lawyer that might be able to do a limited representation and help you to draw up the divorce orders, the decree, so that it's very well written. So those are my suggestions for you. If you like what you're seeing on our channel, remember to hit the subscribe button. Thank you as always for watching, and I wish you all happy holidays.